Thank you, Director, for being here. It sounds like Mr. Ivey was kind of moving this direction, last week, PTO submitted an advance notice of proposed rulemaking process or proposing substantive changes to inter partes review process. Can you just walk us through kind of what actions either, by Congress or industry, what prompted the proposed rule?
It started when there was some concern about how the USPTO exercises its ability to discretionarily deny petitions that we receive for IPRs. And there was some case law and some guidance set forth before I took on the position of the director. From the beginning, what I've tried to do is initially just clarify what that guidance was so that stakeholders would have certainty and clarity. What the ANPRN does is it addresses stakeholders' concerns about the way the USPTO is implementing the AIA and activities by certain entities to avoid some of the language that the Congress put forth through the AIA. So we did issue a request for comment to hear stakeholders' views on discretionary denial. We received 822 comments. This was about 1.5 years, 2 years ago, something like that. We didn't feel like there was enough information there to go directly into rulemaking. So what we did was hear from more stakeholders over the course of the year, from small entities, from large corporations, from everyone, to hear what they were experiencing. We went back and read those 822 comments and tried to shape different ideas that we could move forward with to make it very clear how the director and by delegation the board is going to exercise their discretion.
So the rule that proposes a change in the test to determine the PTAB review, it kind of abandoned the statutory test from the Patent Act and went from reasonably likelihood to compelling merits test. Can you explain kind of the difference between those two, or how you see the effect of that?
So it doesn't necessarily abandon that, because that overlays the discretion of the director to institute. And so what it really does is it clarifies that discretion, which has been in place for quite a long time. It takes it to the next step, seeks stakeholder input on how that should be clarified and how that should be shaped. So that's the role that the ANPRM would play. In terms of your questions about the test for institution, independent of the discretion to deny institution, the thought with the substantial merits test is, prior to my position, to me being the director of the USPTO, there was some thought that the USPTO was discretionarily denying even when there was a strong case. And so that's where that test came from. Was I believe the intent of the AIA was to get rid of the patents that really were invalid, and I wanted to make sure that the procedures we had took that into consideration when it came to discretionary denial, and that we would not discretionarily deny if it reached a substantial merits test, where we believed it was a strong case and we thought it was best for America not to have invalid patents out there.
So the other thing I would say is when I'm in the district or, touring a business, and, it doesn't come up often, but when patent law does come up, a lot of times there's kind of a level of frustration amongst small businesses that they are not necessarily viewed in the same light that you might see with some of the major corporations that have a army of attorneys available to them. So I'm just wondering, how have you addressed that, or kind of move forward thinking, what are the different levels of business and how could you appropriately interact with them?
Well, and I appreciate that. And in my past life, I represented both large organizations as well as startups. I spent a lot of time with startups. So when I came on board, what I did was look at all the stakeholders the USPTO engaged with. I expanded that to make sure we were getting out there more into communities, hearing from inventor groups, hearing from individual inventors. So the way we shaped the ANPRM was to make sure that we were getting out to people even if they didn't have the ability to come to us. And so we believe that the ANPRM really takes into consideration all stakeholders, not just those who might ordinarily have access. It's all been about access. The other thing that I did is I started up a new Engage with the Director website so that anybody that has something they want to contribute or say can do that. So for me, it's all about, we need more people in the ecosystem. We need to support small inventorship and innovation. We need to give people access. at all levels, including in this process.
Very good. Thank you. Mr. Chair, I yield back.